The state government is set to introduce new no body, no parole laws, denying parole for homicide offenders who refuse to provide information or help to locate their victims' remains. It follows the very high-profile case of Chris Dawson, convicted of murdering his wife Lynette, whose remains are yet to be found. But while it sounds simple, what's the reaction of those in the law? A Central Coast-based criminal lawyer, Manny Conditsis, joins us to talk about this. Good morning, Manny.
Good morning, Scott.
Manny, what will you be saying to the government, or the Law Society are certainly looking at this as well? Will it work?
It won't work. And let me say this at the outset, that laws brought in on the back of emotion, and particularly for political reasons, political advantage, usually turn out to be bad laws. These are bad laws.
Why do you say that? No body, no parole laws exist in Queensland already, Western Australia, South Australia, Victoria and the Northern Territory. What evidence is there that these laws are effective?
That's the nub of the issue. There are other important aspects, but in terms of what evidence is there, there is none. Michelle Reuters, who is an Associate Dean of Criminology Studies in the Remit University, prepared a paper with others not long ago and had a close look at the effectiveness, or how the legislation in these states and territories worked, and discovered that there wasn't one single solitary case where, after conviction, because of these laws, the location of the victim's body was identified. Not one case. They don't work.
Can you give us some scenarios? I mean, as an experienced criminal lawyer, what is going on in the courts, pre-sentencing, for example? Why, in your opinion, isn't this a good idea, and particularly being applied retrospectively?
There are a lot of reasons, if you bear with me, because the answer might take a little bit of time. But firstly, a sure sign that the laws are for political advantage, political posturing, is that there was no consultation with the relevant bodies, i.e. the Bar Association or the Law Society. There was none here. This legislation was announced after the Chris Dawson murder trial and Mr Dawson's conviction, which, as I understand it, is subject to appeal. Had there been consultation, there might have been able to be some middle ground reached in respect of a number of problematic areas. Let me identify some of them. There are reasons that a person may not know where the body is, even assuming, following a conviction, that the offender is in fact guilty. Making that assumption. For example, the body could have been disposed of at sea, the body could have been disposed of in the river, there could be unidentified co-accused who might have disposed of the body, not this particular accused. Then you come into issues such as mental health, whether it's dementia or other mental health issues in respect of which the offender may not know, may not genuinely, legitimately know where the body is located, right? Based on these laws, the State Parole Authority, and they should not be the authority that makes this determination, but I'll come back to that if we have time, but the State Parole Authority must, that's what the legislation says, rely on what? No evidence, but a report. A report from whom? Police, who could hardly be said to be objective in the matter. They put together the brief upon which, on this assumption, the person was found guilty. They are not objective. They could not be said to bring impartiality or objectivity to the table. The SPA, the State Parole Authority, must rely on the report from police. Not only that, but the police, in the preparation of this report, do not have to provide one scintilla of evidence to support the conclusions they have made in their report. Yet, the SPA must rely on that report. That is, quite frankly, an absurd position. It is a denial of natural justice to the offender who is going to be punished, further to what is already being punished, and I'll come back to that in a moment. It is a denial of procedural fairness that the accused person has no right of reply, has no right of examination of the police who put this report together, and the report could be wholly problematic. And I can come back and speak to you about, and your listeners, about the double jeopardy or double punishment scenario, because the offender in this circumstance is likely to have already received an additional sentence because he or she has not disclosed the location of the body.
This isn't a bad idea in theory, though. We're speaking with Manny Conditsis, criminal lawyer, about the no body, no parole idea that's being floated by the New South Wales government. Surely this would be better done in sentencing by a judge.
Following a conviction, there is a sentence hearing. Following the sentence hearing, the judge imposes a sentence. During the sentence hearing, there are many matters that a sentencing judge has to take into account. Many. Far too many for me to go through with you now. But one of them is that the offender is adequately punished. Another of them is that the judge has to consider whether the offender has shown genuine remorse or contrition. A factor leading to whether the offender has shown remorse or contrition is whether the offender has cooperated, assisted with the authorities. At the sentence hearing, it's presided over by the sentencing judge, the judge who sat in the trial. That judge is in a perfect position to know all of the evidence relevant to the trial, to know whether based on the evidence, not a police report, but on the evidence, whether it is likely that the offender would know where the body is located. That judge then hears the evidence, and in circumstances at the sentence hearing where the offender has not cooperated, has not given any evidence, or refuses to identify the location of the victim's body, that is a factor that will go against the offender at the time of sentence.
Well, why can't that judge say you will not get parole, you'll serve your entire sentence because you haven't told us? So that certainly, wouldn't that take the pressure off the parole board, who are more geared up to look at the behaviour of someone in jail and decide whether they're a threat to society rather than dole out punishment?
I anticipate the position of the Law Society will be that the body or the person, the authority to make that determination should certainly not be the State Parole Authority, which quite frankly is in that task it is being given by the government is in complete conflict with its task in overseeing assimilation to the community, rehabilitation, so on and so forth. That task should be the role of a Supreme Court justice with...
At the time of sentencing.
It is taken into account without this legislation. So on the one hand, one view, and indeed one reasonable view, is you don't need the legislation because it is already taken into account at the time of sentencing. However, if the powers that be are not satisfied with that, then put the determinative power not in the hands of the State Parole Authority based on a report by police, but in the hands of a Supreme Court justice. Now, whether it's the same justice who presided over the trial or it's another justice, that could be a matter for debate. But it should be a judicial process that is going to add years and years and years to a person's incarceration, not the way it is presently formulated.
What if the person hasn't done it, which has happened on the odd occasion? What impact could this law have on someone then?
Well, that brings about this point, which is that this legislation, again, reveals an absurd, at least a potentially absurd position. In that scenario you've just articulated, you could have a person who has been convicted beyond a reasonable doubt, but as we know, history has taught us that that doesn't mean 100% that the person is actually guilty of the crime. In that scenario, the person who has been wrongly convicted, in fact, doesn't know where the body is, yet he or she will be punished. Compare that with the person who has been properly convicted. Then the person who has been properly convicted, based on this legislation, will in some way be advantaged against the person who may have been wrongly convicted.
Summing up, Manny Conditsis, final words to the court?
Two things I would say. One, retrospective laws have been shown to be proven to be bad laws. This is a bad law. The retrospectivity nature of it is bad. People have been sentenced based on the law as it was at the time. They're now going to be further incarcerated potentially based on these laws shouldn't be. Lastly, this, rather than a stick in terms of we will do this and you will spend more time in prison if you don't reveal the identity of the body, what about the potential for a carrot rather than a stick? What about an earlier release date, maybe not by much but by a little bit, with what intention in mind, with what objective in mind, to give the family that knowledge that they would be so much be craving for, right?
So something could be done, but the way they're doing it, you don't agree with it?
Absolutely not.
All right. Manny Conditsis, thanks for joining us on the program.
Thank you, Scott.